to this bill. If you'd like a copy, I have some extras. Okay. Did you say you had somebody that was coming in? Okay. Okay, great. We should have plenty of time. Sorry if I'm a little harried. It's been a busy day for everybody, I guess. Okay, let's get started. This is the House Subcommittee on HF2287. I'm Charles Thompson. I represent District 58. Would my colleagues please introduce themselves?
Representative Craig Williamson from House District 11.
Representative Angel Ramirez, House District 78.
So this bill has to do with selling of vaccines in Iowa and administering vaccines in Iowa. There is an amendment that says, just in summary, about a 3-page amendment, that a vaccine company may obtain a waiver in Iowa if they negotiate it with a patient and the patient signs after informed consent. So are there any comments on this bill? Please come to the microphone. Press the button on the right, say your name and who you represent, if anyone. And we have a half hour, so people should have plenty of time for their remarks. Thank you.
Thank you, representatives. My name is Jessica Highland. I'm with the Iowa Biotechnology Association, and I've brought an expert in the space of the vaccine compensation program at the federal level, who would be able to speak to how these injuries can be compensated. Her name is Patricia Campbell-Smith, and I will turn it over to her.
Thank you. Good afternoon, Mr. Chairman and members of the committee. As indicated, my name is Patricia Campbell-Smith, and I am here as a consultant to the Biotechnology Innovation Organization, or BIO. In respectful opposition to HF2287, BIO has submitted written comments. I am a now retired federal judge, having previously served as the Chief Special Master of the congressionally created body to hear vaccine injury claims nationally, present today to offer information regarding the distinctive features of the venue informally known as the Vaccine Court. Created by statute in 1986, the Vaccine Injury Compensation Program, or the VICP, offers a no-fault, claimant-centered pathway to compensation. Petitioners file claims under the VICP with the Vaccine Court, titled formally as the Office of Special Masters, or OSM. Notably, the Vaccine Court is a component of the United States Court of Federal Claims, the jurisdictional mandate of which has been to hear claims against the United States since 1855. Vaccine court claimants specifically benefit from separate recovery for their legal expenses and for their own damages, which may, if appropriate, include incurred medical expenses, lost wages and future earnings, pain and suffering, and any required home modifications. This prescribed format for recovery protects claimants from the diminution of any obtained personal recovery in other fora. Additionally, vaccine court claimants benefit from the presumptive admission of all evidence presented to the tribunal, with credibility and reliability determinations to follow. This differs markedly from the evidentiary standards applied in state and other federal tribunals. It is by design that the federal court provides a clear path for recourse. If petitioners are unsatisfied with the outcome of such proceedings, they retain the option to sue in another venue. To recover elsewhere, however, suit must have been filed first in the vaccine court. National access to the vaccine court contemplates, as a convenience to the claimants, the conduct of proceedings in federal courthouses nearer to those who reside outside of Washington, D.C. And finally, claimants receive jurisdictional priority in the vaccine court in contradistinction to other courts, as the sole claims considered are vaccine related. I thank you kindly for the opportunity to be heard and to draw to your attention these unique features of the vaccine court.
Thank you.
Thank you.
Would anyone else care to be heard on this topic?
Yes, I would. My name is April O'Toole. I'm with Informed Choice Iowa. We applaud and support this legislation to restore justice to those who have been injured by a vaccine. The liability shield was not made in pursuance thereof to the Constitution from the start, removing the rights of those injured to receive justice as outlined by the 5th, 6th, and 14th Amendments to the Constitution. The attempt by the government to appease that due process through vaccine injury compensation program hasn't delivered on the promises it made to families advocating for justice back in 1982. The program was designed to be an expedited, less expensive, and more predictable administrative alternative to filing a vaccine injury lawsuit, but for more than 98% of plaintiffs, it is the exact opposite. Unfortunately, the ICP claims now take greater than 6 years to settle, when the original issue in the early 1980s was the long wait times for justice within the courts. They undergo intense litigation prior to compensation, which defies the expedited intent and more closely mimics civil court, all without a jury or discovery being allowed, again defying the justice set up within the Constitution. Additionally, the compensation for death was set at $250,000 in 1986, and that has never been adjusted for inflation. As of 2020, that number adjusted would be $572,780 if they were to just wanting to keep with the same valuation as in 1986. When you do not have the consequences of liability and you have the government and states across the nation providing with free advertising while mandating children to take the product for school entry, you prevent the incentives for companies to make their products safer, which is what design defects claims encourage companies to do. Thank you.
Hi, my name is Lori Harvey from Boone with Health Freedom, Iowa. In 1986, President Ronald Reagan signed the National Vaccine Injury Compensation Program to protect vaccine manufacturers from lawsuits from parents whose children were injured or died after vaccination. The Vaccine Injury Court is run by a politically appointed judge. There is no jury to help decide the outcome of the case. This alone violates our constitutional rights to a jury trial. 3 out of 4 kids are denied any compensation for their injuries or death. Families are then saddled with the burden of caring for the injured kids for the rest of their lives. That current cost is estimated to be $1.5 million. The Vaccine Injury Compensation Program has been stripped from its original intent. The Department of Health and Human Services and Justice have violated the spirit and intent of the law, and turned what Congress promised parents would be a non-adversarial, expedited, and informed process into a highly adversarial, lengthy, traumatic, and unfair imitation of a lawsuit. Part of the 1986 Act, vaccine manufacturers are to submit safety reports to Congress every 2 years since 1989. To date, none of those tests have been done. A lawsuit by the Informed Consent Action Network asked for those records. None could be brought forth. Another lawsuit was done by the Informed Consent Action Network asking for the double-blind placebo trial records. Anthony Fauci had to admit no placebo trials were ever done. No vaccine has had any double-blind placebo testing done. The newer vaccines are tested against the older ones. None use an inert solution like saline. Double-blind placebo is the gold standard that applies to all medicines except vaccines. All medicines have some sort of liability except vaccinations. This is wrong in every sense of the word. Vaccine manufacturers make the vaccines and then also sell the drugs to help the kids and adults who are vaccine injured. Vaccine manufacturers have no incentive to make their products safer as they have liability-free product. The schedule is added to with no science behind it. One of the leaders said at an ACIP meeting that they have no data to give multiple vaccines at once, but just put them in different limbs. Tom Frieden, director of the CDC, said in a presentation, they've never tested the vaccine schedule and aren't allowed to do that test. A Supreme Court decision in 2011 in the case of Brusiewicz versus Wyeth, vaccines were determined to be unavoidably unsafe and they have an inherent risk that cannot be designed out. The inserts that come with the vaccines that have never been tested for carcinogenic, immunogenic properties, or if they will impair fertility. The insert also says unknown how it will affect a pregnant woman. Vaccine manufacturers need to have the liability immunity stripped in order to protect Iowa children. Vaccine manufacturers need to be held responsible if a child is injured or killed. $67 million has been paid out so far in 2026 for vaccines, injuries, and death. $5.5 billion, that's B, has been paid out since 1989. Nothing says vaccines are safe and effective and having zero liability for the product. None of us would drive a vehicle if the manufacturer knew there was a design defect and that was going to cause a lot of injuries and or deaths, and the manufacturer was immune from liability. I urge you to pass this bill to the full chamber and send it onto the governor's desk. Iowa kids will thank you. Iowa parents will thank you. And I thank you for your time.
Thank you for your comments. You just reminded me of a housekeeping matter. Could I request as an accommodation people who have written their comments and read them to us, which is fine, email a copy as a courtesy to us. My email address is on the legislative website, Charles Thompson. Thank you. Please continue.
Thank you. My name is Brittany Lumley. I'm here on behalf of Pharma. We are registered against this bill, and I'll be reading comments too, so I will make sure to get these to all of your inboxes. But I will start by saying we're registered opposed to the bill. Continued investment and support for vaccine innovation and access to essential is essential to U.S. leadership and keeping communities safe. And bills like this bill disincentivize companies and investment of our resources and expertise in research and development for future prevention, treatment, and cure of diseases. Further, it disincentivizes innovation among vaccine manufacturers and makes it challenging to do business in the state of Iowa. Much like other industries, the biopharmaceutical industry supports a predictable, science-based review process for all new treatments and vaccine candidates by the US FDA. Clinical trials for vaccines are crucial in this process, and it's a vital step to ensure that vaccines are both safe and effective. The groundbreaking biopharmaceutical research happening today is laying the foundation for medical advancement, allowing us to tackle diseases across the spectrum. So there are a couple of issues I want to point to with the bill. The first being that this, as it's a constitutional issue, and it stripping immunity under federal statute is preempted under the Supremacy Clause of the U.S. Constitution. It purports to override all immunity granted to pharmaceutical companies under federal law, including some of the National Vaccine Injury Act and the Public Readiness, Emergency and Preparedness Act, and the Project BioShield Act, and the Defense of Production Act. Sorry, this is really small. I'm going to make this bigger. So that's our first issue I want to highlight on the constitutional side of things. Additionally, pharmaceutical companies already fund the Federal Vaccine Injury Compensation Fund. I know there's been a lot of talk about that today, which is a no-fault system that compensates patients found to be injured by certain commonly used vaccines. We've talked a lot about it, so I won't get into it, but what this imposing additional state, civil, and criminal liability on pharmaceutical companies is inconsistent with what's already been passed. And a couple points I want to raise too, that this program does not shield manufacturers. People are still eligible. The whole program existed to streamline the process and it was intended to resolve vaccine injury claims. And there are still rights of recourse when people can still pursue civil lawsuits against a vaccine manufacturer if they are dissatisfied with the vaccine court's decision. And also, I will note that like any program, can it be improved? Absolutely. However, I want to highlight that this is a federal situation and we're talking about state laws, and so how that all placed together could be problematic. So happy to answer any more questions, but because of these reasons, we are registered against the bill. Thank you.
Good afternoon. Lindsay Maher, resident from Pleasant Hill, Iowa. I just wanted to talk about a few things. Number one, most of the injuries that get compensated need to fall in line with the vaccine injury table. And unfortunately, since 1995, a lot of the injuries that were originally put into that table after 1986 were removed. And a majority of cases now fall outside of the vaccine injury table, which is why litigation now takes upwards of 6 years, which is what it took previous to the National Vaccine Child Injury Act passing. Vaccines are on the market now that do not have this immunity. So the pneumococcal polysaccharide and the shingles vaccines are on the market today without this liability shield. A shingles vaccine known as Zostavax was pulled from the market in 2020 due to lawsuits for design defects due to many patients experiencing shingles from the vaccine itself, since it's a live attenuated vaccine, or other severe side effects such as paralysis, blindness, and brain damage. Another shingles vaccine then entered the market. That was not live attenuated virus vaccine, so it cannot cause shingles as the previous vaccine was accused of doing. It has far less severe side effects, and it remains on the market today. That is the power of accountability, safer products into the marketplace. Clearly, it is not impossible to make products that are safer for consumers. They can still be held liable when necessary and make profits for their companies. This industry is a very profitable industry. A lot of the times I think they want to say that it doesn't make money, and we're not going to allow them to make money if we take away their liability. But remember that a lot of the research dollars that go into these drugs are from the federal government grants. The vaccine industry as a whole will reach about 60 or $95 billion in 2029, according to Statista. In 2017, a delitigation study done by Gail DeLong actually found that products that entered the market after the Vaccine Injury Act was passed had significantly higher incidence of adverse events than vaccines that were licensed under previous regimes that permitted consumers to sue. That is the only delitigation study that I've seen that has been done on these vaccines. In addition, just look at the Iowa numbers. There's been 16,131 total reports of vaccine injuries on the VAERS database. That is one of 4 vaccine adverse event databases, and it has an underreporting of, they estimate about 99% or tenfold. They don't know for sure. But if you think about that, 16,000 injuries, that could be upwards of 1.6 million Iowans that have been injured. 1,700 reported as serious, 1,084 ER or doctor visits, 242 reports as life-threatening, and 344 deaths, all in the state of Iowa from vaccine injuries. And the COVID data is not any better. Actually, it passes Vioxx for the amount of deaths that have occurred, yet it still remains on the market today. Be happy to leave that information with you as well. So these products need accountability. They need liability reinstated in order to bring better products to the market and protect Iowans, which under the 10th Amendment is something that our state legislature should be doing. Thank you.
Go ahead, please.
I have a few questions if I could call some people up. Ms. Campbell-Smith, if I could ask you a few questions. So you talked a little bit about the factors that have to be met for someone to go through the vaccine program right now. Can you explain those a little bit more in depth? And additionally, I have a follow-up question. If I go through the vaccine program and win my suit, but let's say I'm not happy with the amount of money that I receive, I feel like it's inadequate. Since I've gone through the vaccine program, am I then able to, even though I won, go through a different court system to receive better or adequate reward or recovery?
So I'll start with the second question and work my way backward. If you begin in the vaccine program, you have the options to go elsewhere. if you begin and litigate your case somewhere else, you are precluded from coming to the vaccine program. It has an exhaustion requirement that you have to, the vaccine court does, that you have to begin there. That's one of the conditions, which brings me back to your first question. Among the conditions is that your initial claim for recovery for a vaccine-related injury occurs within the program. Harm has a particular definition. It has to be a condition that has persisted for longer than 6 months. And so those are among the conditions. There is nothing that's excluded in terms of how a claimant can establish their claim. Unlike, as I alluded to earlier, among the conditions is in the vaccine program is that a claimant can produce any evidence to include medical records, expert testimony, physician testimony, scientific studies, whatever a petitioner elects to produce is all presumptively admitted and creates part of the record. And that's the record that's examined. So those are chief among, and those are statutorily defined criteria that allow a case to move forward. It formally was that it was one administered injury, one administered vaccine related causing one injury. That has been expanded to contemplate that pregnant women who, for example, received the flu vaccine may have a claim for themselves plus a claim for the fetus in utero. So that has come out of judicial reasoning that while it is one vaccine that's been administered, technically there's the potential for 2 injuries. But those are all predicate conditions for filing a claim before the court. Does that answer?
It does. And can you maybe draw the through line of how that relates to this bill, right? The potential impacts that you might be concerned about, specifically for the public that might be listening and might not understand how the vaccine program specifically relates to the manufacturing companies.
So the vaccine program, and I can really only speak up. I've clerked and worked as a practicing lawyer in highly regulated industries, but I can comparatively speak to practice before other jurisdictions. But my specialty, if practice-wise, has been within the vaccine court and seeing what that distinction is. And that through line is that here it's claimant-centered. I use the example, if you invite 10 kids to a luncheon, you pre-cleared who can be served what, you provide peanut butter sandwiches, and one child appears to get sick. That is not perceived in this legal rubric as a problem with the peanut butter. That's something that is a product design defect. That is something unique about that child who may have a previously undiagnosed peanut butter allergy. That's the kind of claim that gets heard and focused upon in the vaccine program. So it's even the predicate with the no liability is that it's a safe vaccine and there are other resources and places to go if you want to challenge the safety of a vaccine, but it's the nature of the court itself that you assume that everything you're working with is legal and safe and you're looking for an injury that has occurred for that particular claimant. So you're looking at genetics, you're looking at profiles. Written decisions have to issue unless a claim settles. Written decisions that outline exactly what the nature of the injury was, what was the proof, what was the vaccine received, what testimony, what record was produced, and the ultimate outcome has to issue in each case. That is part of the reason that the claims take longer. because judges have to issue those decisions, bless you, in every case, which is not the circumstance if you're in front of a jury and you get you just get a decision, but not necessarily an awareness of what has happened. And so in that circumstance, it is not the purpose of the court. The purpose of the court is to compensate those who have been injured. There are only 8 special masters that do it. The table and the number of vaccines that are covered has multiplied over a period of time. So that has created a bog on the caseload, but it means that there are people who know and have experience with what they're looking at. And when they write decisions, it has the benefit of providing information to others about what's emerging that may not have been, that can't be captured in other fora.
Can I just jump in there?
Sure.
To follow up, there's some testimony from April, are we buzzing here? April Toole, Lori Harvey, and Lindsay Mayer criticizing the system of the vaccine court for not making claimants whole in a timely manner. Do you have any response to that? Do you think claimants are being made whole under this system?
Again, I'd like to point out there are only 8 special masters nationally that hear, and that's a statutory limitation. So it is a jurisdictional priority that the only thing that is considered are vaccine cases, but they also have to...
I think you may be answering a different question. My question had to do with are claimants being made whole by the current system? There were some descriptions that the current vaccine court system is failing claimants, failing to restore them to the condition that they were, at least financially, as best as we can through the tort system. Is that happening, do you think? What's your response to these ladies?
I'm sorry, thank you for clarifying, because I do want to be responsive to that. And I do think that that's different in the vaccine court as opposed to other fora, because if
So
a
you
vaccine
agree that they're
claimant...
not being made
No,
whole?
that's not what I'm saying. What I'm saying, if I could just finish, is once a claimant has prevailed, they get all of the expenses, incurred medical expenses, future lost earnings, any home accommodations that are necessary, pain and suffering, which is statutorily capped. In that instance, and it's also managed by an annuity. So it's very structured for a claimant, which is distinctive when you talk about being made whole to be restored, at least financially. There are resources in place because this anticipates in the most catastrophic or the most difficult cases, there are irreversible health consequences.
Is death capped at, recovery capped at $250,000?
That is a statutory mandate.
Do you think that that's making people whole in these circumstances?
That is what, as judges, you have to apply the law. That's a function of law. That is.
Well, I understand a cap's a cap, but do you think that people are being made whole through that system?
I think that's something that they would have to explore with Congress because that is a limitation.
Do you have an opinion on that one way or another, personally?
I can only speak to what my testimony and my area of expertise is not about opinions. It's what I write, which is based on facts and law.
Sure. And then as these cases move through the system, people have an option to go into to leave your system and go into the regular tort system. Is that correct?
Absolutely.
And how often does that happen?
Rarely.
And do you know how many jury verdicts have followed from people who are doing that?
My impression is that they have not been as successful, but there are different barriers to recovery, to include some of the cases that we hear get stopped because of the discovery requirements, which mean that the testimony and the evidence being put forward is not admitted, and that undermines a claimant's case.
Are you aware of any jury determinations following people opting or being dissatisfied with the result in the vaccine court who moved on to district court and their remedies after that and gone to a full jury trial? Are you aware of any jury case?
Gone to a full jury trial and have prevailed?
Yes.
I have no personal knowledge of that. I'm not saying that hasn't happened, but I have no personal
Okay.
knowledge.
Well, I do want to be mindful of the clock. Did you have any other questions? Did you have any other questions?
So my understanding of this bill is that, well, one of the concerns that I have that I'd want us to be considering is that this might impact the future of manufacturers of vaccines wanting to have business in Iowa, which could lead to subsequent problems, public health concerns that I'm a little bit weary about. Could you speak a little bit to what's consideration? Okay, you might have to follow up with us because we're almost done, but curious about how this might impact the future of vaccines in Iowa, and specifically what diseases might we have to be on the lookout for.
I'll be very brief. We are opposed to the bill. I didn't say that at the beginning for Iowa Bio, and that is a concern. We're not sure what the effects of this would be, how manufacturers would react, so I'll just leave it there. But any vaccine that's manufactured and sold, we are concerned with how this would affect the future of how liability is handled in the state.
We're almost out of time. Representative Williams, any comments?
I've got a lot of comments, but I think we'll wrap it up.
Okay. I have a lot of comments too, but I think people are itching to take over the room. So that concludes this subcommittee. I'll be voting to advance this. Representative Rodriguez will you be?
Yeah, I'll vote to advance it. I've got a lot of questions on it, but let's move it forward and talk one more time.
Okay, that concludes the subcommittee. Thank you, everyone.